Hi, good afternoon if you are on the East Coast. Good morning if you're out west. My name is Aaron Lacey. I'm a partner in the higher education practice at Thompson, Coburn, LLP. We are a law firm based in St. Louis, but with offices like a lot of big firms all over the place. You are tuning in today to an examination of the recent ED, that stands for Department of Education, guidance concerning the bar defense rule, and this is a big rulemaking package that has taken many shapes over the last several years and that the department has been and continues to work on. The focus of the presentation today, I'll just start at the outset, even before I get into housekeeping. I just want to emphasize the focus of this presentation is not to give a comprehensive review of the entire rule, right? The focus of this presentation is the guidance that the Department of Education recently put out and the implications of that guidance. But we have done, I was counting up earlier, I think we've done now 15 or 16 webinars over the last 3 years on the bar defense rule. And we did a series right after the 2016 rule became final. That was a comprehensive 4-part, 90-minute-a-shot webinar series on the 2016 rule, and if you're interested in that, it is available on demand. If you look in the webinar announcement that went out for this webinar, we included links to those webinars back when we did them. So you're welcome, if you want a more comprehensive review, to go visit those, and we'd love for you to do that. Housekeeping, I just want to emphasize this presentation has not been approved for CLE. Most of our webinars are. So if you are an attorney and you were looking for continuing legal education credits, I apologize. Today's webinar has not been approved. That's just because we put it together as a special webinar on quick notice. We do have one tomorrow, though, at noon, that is going to be on intellectual property. It's a patent and privacy-focused webinar that will be good for CLE credit. So if you can stomach 2 days in a row of webinars for lunch, you're welcome to come back. At the bottom of your screen today, you'll see that there are various little widgets. These are all resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen as well. If you have any questions during the webinar, please submit them through the Q&A widget, and we will try to get to them at the end. We're going to save them for the end. A copy of the slide deck is available in the resource list widget, and if for some reason you can't find it or you have other troubles, just let us know and we will get you a copy. An on-demand version of this webinar will be available, I hope, by tomorrow. We have a new platform that we moved to this year, and it allows us to get the on-demand versions out and on YouTube pretty rapidly. I will also just say at the outset, I'm going to cover a lot of content today. If you feel like it is a lot to process, that's okay. You know, let it wash over you. Take in what you can, and just remember, this is going to be available on demand. You'll have the slide deck, you'll have the webinar, and you can go back and look at it at a later date and sort of piece through it at your own pace. There is a survey that we always ask folks to fill out. We appreciate your feedback regarding the quality of the webinar and ideas for future reference. And the last thing I'll note is if for some reason you have any kind of freeze up or technological challenge with the webinar, we have found that pressing F5 often will help overcome that. We don't get a lot of issues, but occasionally when folks do, that refresh seems to take care of it. Okay, so let's get going. My name is Aaron Lacey. I mentioned at the outset I'm in the higher education practice here, and my real focus is on the regulatory aspects in higher education. So I spend a lot of time thinking about those federal, state, and accrediting laws and standards that govern post-secondary institutions. In our practice, we also represent schools in front of regulatory agencies and employee and student litigation and assist with post-secondary transactions, policy drafting, et cetera. Now, I'm going to do the majority of the presentation today, but my partner, Jeff Fink, is also going to join us at the end to talk about, in particular, the implications of this guidance on arbitration, pre-dispute arbitration clauses, and class action waivers. Jeff has a tremendous amount of experience as a litigator. He also works a great deal in the higher education space and has represented institutions in lawsuits, does program review work with me in front of the U.S. Department of Education. He's a very knowledgeable guy, and he's spent quite a bit of time over the last few years following and thinking about pre-dispute arbitration clauses and waivers, and I asked him if he would join at the end to give you some practical thoughts about what's going on right now in the space and how this guidance plays into that. Here's the presentation overview. I'm going to start with the bar defense rule, then we're going to talk about the framework. We're going to talk about the financial responsibility reporting requirements, submission of arbitral and judicial records. Then we'll get in the end to the pre-dispute arbitration clauses and class action waivers. I want to emphasize that while I'm going to give you a little bit of context around the rule, my main focus and one of my primary concerns for you as institutions is making sure you're aware of these various reporting and submission requirements. I will also highlight, I noted in our registration list that I was gratified to see that we have institutions from every sector, public, private, nonprofit, for-profit career schools, all are tuned in. And that's good because this rule applies to everyone. There are aspects of it that will only impact certain types of institutions in certain sectors, but most of the rule and most of these reporting and submission requirements apply to all schools, and it's really important that they be aware of that. I know sometimes there has been an impression that this rule is largely intended for or applies to schools in the for-profit career school sector, and one of my concerns is that institutions outside of that sector, meaning public and private nonprofit, may not fully appreciate that they have significant reporting and submission requirements as well. So to those of you in those other sectors who are on today, thank you. And if you think you have colleagues in the industry, other general counsels at other institutions that may not be aware of this rule, please feel free to pass them this webinar or at least make them aware. All right, so let's first talk a little bit just to create some context about the bar defense rule. For those of you who have tuned in for 14 or 15 of my webinars on this topic, bear with me. I'll go through this quickly, but I want to make sure that we all understand what we're dealing with. So, BDR1, the first version of this rule, right? In 1993, Congress created the direct loan program, and as part of that legislation, Congress said to the Department of Education, all right, we want you, department, to specify in regulation what it is a school might do, the acts or omissions of an institution that a borrower could assert as a defense to having to repay their loans. So in other words, I'm a borrower, I took out money to go to a school, and after the fact, I feel like my school did something or didn't do something, and I want to tell the department I shouldn't have to pay back my loans because my school did X, Y, or Z. And so here we've got Congress telling the Department of Education, we want you to specify what are those things that a borrower might assert, what acts or omissions. So the following year, in 1994, the department said, okay, well, a bar defense claim, and I use BDR for bar defense to repayment, a bar defense claim would be any act or omission of the school attended by the student that would give rise to a cause of action against the school under applicable state law. So if your school did something that you could ostensibly go to court under your state law and sue the school over, that potentially could be a basis to get your loans discharged. The next year in 1995, the department added a little more information and sub-guidance. They noted that the cause of action has to directly relate to the loan or the school's provision of educational services for which the loan was provided. So in other words, a slip and fall claim, a claim based on sexual misconduct or racial harassment, for example, would be excluded. Those would not be a basis for a bar defense claim. Whatever it is you're saying your school did, it has to relate to the making of the loan or the provision of educational services for which the loan was provided. Keep in mind that provision of educational services is very broad, but there are some things anyway that the department acknowledged would be excluded. The department did not articulate a process for recovery actions against schools, but acknowledged that schools were entitled to due process. By the way, what do I mean by a recovery action? So we've sort of got two concepts here, right? The first is you've got a claim by a borrower, or the assertion of a defense to be technically accurate, and they're saying I shouldn't have to pay back my loans. And you're going to have some adjudication process where the department is going to say, okay, we believe that you're right or you're wrong. If the department chooses to discharge the loans through that process, then there's the question of whether or not they will seek to recover the amount discharged from the institution that committed the act or omission. That's what I'm referring to when I talk about a recovery action, right? And at this point back in 1995, the department really didn't articulate in any way how it would go about recovering those amounts. I will note, though, for the institutions on the line, and this is a significant point, that the law explicitly tells the department that it should try to recover from institutions. So that's why schools should care about this, among other reasons, is that if the department discharges a loan, it then has a mandate to try to turn around and recover the amount discharged from the school. For two decades, this framework was sufficient. My understanding, I've heard different numbers, but prior to 2015, the department only had a handful of claims or defenses that were ever asserted. Then you had the collapse of Corinthian, the large career school group that was based out of the West Coast, and that landscape totally changed, right? By November 2017, there had been 118,000 bar defense claims that have been filed, representing about $2.4 billion in potential loan discharges. So suddenly the department had a significant issue on its hands and realized it really had no process or infrastructure to appropriately manage all of these claims. So in 2015-16, under the prior administration, the department carried out a negotiated rulemaking, and the purpose of that was to create a new bar defense framework that it could use for adjudicating and processing these claims. What's critically important to understand, though, is that in addition to coming up with this new framework for adjudicating bar defense claims, when the department in 15-16 announced this rulemaking, it also indicated that it was going to take on a number of other topics. So not only did it come up with a new bar defense framework, but it also significantly revised sections of the financial responsibility regulations. It took on arbitration agreements. It took on closed school discharge, false certification discharge, had a new definition of misrepresentation, and introduced this idea of repayment rates. That was the only piece of all of this, I will note, that was specific to proprietary schools, right? All the other pieces had potential implications for schools in all sectors. Okay, so it was a much bigger rulemaking package. All of it, in one way or another, would tie back to bar defense or the ideas around bar defense, but it's important to understand that the rule we're talking about goes far beyond this process for adjudicating claims and recovering from schools. And a lot of that we're going to talk about today, because a lot of the reporting requirements actually fall under these other elements and not under that primary process. Okay, so the BDR2 rulemaking did not produce consensus, which meant the department was free to articulate a rule based on its own thoughts and desires, and a new BDR2 rule was published in November 1st of 2016, which was supposed to become effective July 1, 2017. In January of 2017, January 19th, which you may recognize as the day before the inauguration of our current president, the department issued supplementary BDR2 procedures that govern those recovery actions, right? Those regulations, by the way, became effective immediately and are on the books and have been on the books since January 19th, 2017, and they're found in subpart G of 34 CFR 668, and again govern the process by which the department would recover from institutions. But what about that main rule that was supposed to become effective July 1, 2017, the big sort of substantial BDR2 rulemaking package? In 2017-18, the new administration delayed almost all elements of it until July 1, 2019, and then they carried out a new negotiated rulemaking to create what was going to be their version of bar defense. And some of you may know I was one of the negotiators that was appointed to work on that rule. Once again, consensus was not achieved, and a proposed BDR3 rule was published July 31st of last year, 2018. It was expected that a final version of that BDR rule would be published by November 1st, 2018, and would become effective this year on July 1, but that didn't happen. There was a blow-up. In an order dated September 17, 2018, a U.S. District Court Judge Randolph Moss found that the current administration's delay of BDR2 was unlawful. Simultaneously, there was litigation that had been brought by CAPS, the California Association of Private Post-Secondary Schools, that was intended to delay or enjoin elements of BDR2, and Judge Moss threw that out. Right? So in sort of a period of days, you had the judge first determine that the current administration's delay was unlawful, and second, throw out the CAPS bid to enjoin certain elements of BDR2. Consequently, the path was cleared, and BDR2 became effective. I've seen different dates, but more or less in October 2018. October 12th is the day we use. So the department did not make that November 1 target date for issuing BDR3. And consequently, July 1, 2020 is now the earliest date that a new version of BDR3 could formally become effective. They've indicated that they're going to come up with a new notice of proposed rulemaking, so they're going to sort of redo the whole thing. But that's the last you're going to hear for the most part about BDR3 in this presentation, because the fact is we don't even have a proposed version of BDR3. What we're dealing with is BDR2. And on March 15th, 2019, the Department of Education released significant guidance regarding how schools should comply with that BDR2, the 2016 version of bar defense that is now on the books and in effect. Okay, so the first thing the department said, let's just talk briefly about the framework itself. They indicated in their guidance, and they didn't talk a lot about this. Most of the focus of the guidance was on the reporting and submission standards that we're going to talk about a little bit later. But they did indicate in the guidance that BDR2, they acknowledged that it establishes a new federal standard for the adjudication of bar defense claims based on either judgments against schools, breaches of contract, or substantial misrepresentation. And this administration acknowledged that this standard will be applied for bar defense to repayment claims that are asserted by borrowers as to loans first dispersed on or after July 1, 2017. So this is a really important thing to understand. We actually have two bar defense standards that are in play right now, not one, right? So remember, I started with the origin story, and I said, way back in 1994, the Department of Education said a bar defense claim is one based on an act or omission that could give rise to a cause of action under state law, under applicable state law. So that standard, the BDR1 standard, is still applicable for loans first dispersed before July 1, 2017, which of course is the vast majority of loans that have been dispersed and are outstanding right now, right? If you look at the total sort of $1 trillion plus loan portfolio that the Department of Education is dealing with, almost all of those loans, the vast majority, were first dispersed before July 1, 2017. So if a borrower brings a claim, right, based on, and it concerns loans first dispersed before July 1, 2017, it's still going to be under that old standard of whether or not the act or omission gives rise to a cause of action under state law. It is only those loans that have been dispersed for the first time after July 1, 2017, I lost my July there in the box, but it's after July 1, 2017 that the new standard will apply, right? And will continue to apply until we get a new version of this rule. So let's talk about the two standards. For loans before July 1, 2017, so the vast majority, if a borrower were to bring a bar defense claim, this is essentially the standard and framework that would be in place. First of all, affirmative claims are allowed. So in other words, a borrower doesn't have to actually go into default. They can assert the claim before they go into default. It doesn't have to actually be done in the context of a proceeding with the Department of Education. Okay, the BDR claim defined, so it must give rise to a cause of action or state law and relate to the making of a loan or educational service, right? The time limit for borrower to assert the claim, there isn't one. All right, let me say that again. So there is no statute of limitations. There's no time limit for borrowers to assert claims for loans first made before July 1, 2017. However, there is a time limit for the department to seek recovery. It's the later of 3 years from the borrower's last award year, or whatever the state law statute of limitations would be on that underlying claim, unless the school received a qualifying notice of the claim before either of those periods expired, in which case there would be no limit. So what about the framework we now have for loans after July 1, 2017? First of all, again, affirmative claims are allowed. So in essence, a borrower can go online and fill out an application. They don't have to be in the context of a proceeding where they're asserting a defense. BDR claim defined. So this is a very different standard. Instead of a bar defense claim being about a state law, there's a new federal standard that the department created in 15-16 when they created BDR2. And it basically requires that the student either demonstrate that they have a judgment in court or that there was a breach of contract or substantial misrepresentation. These concepts, substantial misrepresentation is defined in the law. I will just note, again, I'm not going into all of this comprehensively here, but it's a lower standard than you might think, and it does not require an element of intent. So to be clear, you could substantially misrepresent something to a student without intent. You could make a mistake under these definitions that are in place, and it could still be concluded that there was a substantial misrepresentation. I also want to note, particularly for my private, nonprofit, and public institutions on the phone, that a breach of contract does not necessarily mean an enrollment agreement. The department, at least the prior administration, was very clear that in their view, a breach of contract could include, or a contract between a student and a school could include potentially a catalog, bulletin, code of conduct, things along those lines. Now, whether this administration would take the same view or not has yet to be seen, but I just want to highlight that if you don't have an enrollment agreement, that doesn't necessarily mean that there could not be an allegation that there was a breach of contract. Certainly a borrower could make that claim, right? And a plaintiff's attorney or a sophisticated borrower might look back at the prior administration's guidance and use that as support. Time limit for a borrower to assert a claim. So it depends on what type of claim they're making, whether it's judgment or breach of contract or misrepresentation. I'll just leave that in the slide. You can look at that at your discretion. Similarly, there is a different time limit for the department to seek recovery actions. And again, it depends on the type of claim that's being brought. Qualifying notice, I mentioned that for the department when it brings a recovery action, both in the framework for loans before July 1/17 and in the framework after July 1/17, the department's ability to bring a recovery action is limited unless the school had notice prior to the expiration of whatever that applicable period would be. So what does that mean if the school had notice? Under the law, actual notice from the borrower, a borrower representative from the department, if there was a class action complaint that may include the similar types of claims that borrower was making. So the borrower might not even be a part of the class action, but if it's raising the same issues that the borrower has raised in the borrower defense proceeding, then the department could assert that the school had notice or written notice, including a civil investigative demand. The point I really want to make here, and again, you can read through the slide in more detail. I'm not going to read it all. But the point I want to make here is if a borrower could assert ostensibly that the school had notice and as a consequence, or the Department of Education, should say, could assert that the school had notice and as a consequence ostensibly bring a recovery action even after those shorter statute of limitation periods had run, right? All right. So this is what the individual claim process looks like under the 2016 Borrower Defense Rule. The borrower would submit that application to the department. Then the department would grant forbearance, suspend collection. The department would designate staff to review and resolve the claim, so it does not go to an administrative law judge. This is just a staff member at the U.S. Department of Education who's essentially going to be adjudicating the claims. Then the staff would notify the school of the claim. Review evidence, any records that the department has on file. So to be clear, the staff is not restricted to only reviewing documentation provided directly by the school or the student, or borrower, I should say, but can also review other information they may have on hand. So, for example, if an attorney general had an investigation or another agency, or there was a different borrower that previously brought a claim and there was evidence that the department had on hand that was relevant in this claim, they could take that into consideration. Upon request, the staff provides to the borrower the relevant evidence, but just keep in mind under at least this process articulated in 2016, only upon request would the staff provide that evidence. Then they issue that a written decision. And notify the borrower and the school, and the department, if it so chooses within the appropriate time limitations, then can bring a recovery action against the institution. There were a lot of due process issues with this particular process that was set out in 2016. A lot of them were raised when folks commented on the proposed rule. Some of them were addressed in the final rule. A lot of them we talked about in the context of the bar defense, the BDR3 negotiations. So even if on first glance this process looks pretty good, just keep in mind there are some issues with it. Our hope is that it will be administered in a fair way, but it's not perfect from a school perspective. I also want to highlight that the 2016 rule provides for a group claim process, which is essentially like a class action process that could be initiated by the department. But there is no indication from this administration that they will be pursuing or would pursue this option that's in the regulation right now. Okay, but it is worth noting that this group claim process exists in the 2016 law, and the 2016 law is currently on the books. So if it continues to be on the books, a subsequent administration might take a different view and decide to make use of it. Okay, so now let's move into the financial responsibility reporting requirements, which were a big feature of the guidance that was just released by the department. So taking a step back so that you can understand where these reporting requirements sort of fit in, as you all know, there are two sort of critical things that an institution, among others, but categorically speaking, that an institution has to establish to be eligible to participate in the federal financial aid programs. One is that you are administratively capable, and the other is that the institution is financially responsible. And the law, statute, regulation articulates the various things that an institution has to establish to show that it is financially responsible. So one of the things that the administration and the negotiated rulemakers talked about and did when they were crafting BDR2 was to go revisit financial responsibility and to think about whether or not there should be additional components to the financial responsibility requirements. So on this slide, what you see, the things in gray have been there for a very long time. But what the department did in BDR2 is they added this thing in the middle, right? So it's sort of a new component or an element that an institution has to satisfy. In other words, in order to show that it is financially responsible, it has to sort of, at 40,000 feet, meet financial obligations and provide administrative resources. But then the department says in the rule, in order to show that you're complying with this standard, in order to show that you can meet financial obligations, provide administrative resources, right, an institution has to, or sort of thinking of it in the negative, an institution may not satisfy this standard if it's subject to one or more triggering events if they occur after July 1, 2017. And then what the department did was it said, and then we're going to come up with a list of triggering events, right? And so again, if one of these things has occurred at your institution, then that means, at least potentially, that the department could determine that you're not financially responsible. The department took these triggering events, and I'm going to go through them in a minute, but they came up with a whole bunch of them, and they sort of dropped them into three buckets. Right? So you had what they called automatic triggering events. And these were events that if they occurred, then the department would take the information relating to the event and project a new composite score. And then they would use that as a basis for determining whether the school was still financially responsible. Right? They had a second category of, quote, automatic triggering events, which upon their occurrence would automatically result in the department finding that the school failed financial responsibility. So there's not a recalculation of the composite score. And then they had this third bucket of discretionary triggering events that the department would look at, and if one of them occurred, they would determine whether or not they felt like it likely would have a materially adverse effect on on the school's financial responsibility. So here's a way to think about this. The stuff in the first bucket, if one of these events occurs, the department is saying, you know what, we want to know about the event, and then we're going to recalculate the composite score, and we're going to use the composite score recalculation to determine whether it's material to the school. Because it's really about materiality. You know, was the event really material to the school's bottom line and its financial responsibility? If you have one of the events in the middle bucket that occurred, the department's sort of saying, look, just the occurrence of that event we consider material. We're not even going to recalculate the composite score. If that happened, as far as we're concerned, it means you are not financially responsible. And then in that third bucket, the department's saying, we're not going to recalculate the composite score because, and we'll get into it in a minute, these discretionary events may not have a immediate monetary impact on the institution, but there's still things that we think could be significant. So we're going to have to use our judgment to decide whether or not we think it likely would result in a material adverse effect, which is sort of like being an existential threat. It's a high threshold, but the idea is we're going to look at it as a department and determine whether or not it could represent an MAE, material adverse effect, for the institution. So that's why they want the information, right? They're saying we've got this new set of actions, events, occurrences, and we want to know whether these things happen at a school. And then if they happen, you're going to tell us about it, and then we're going to look at it and determine whether or not we think it's material to your financial responsibility. And if it is, then we will act on that. Here are the big buckets, okay? So, and you'll notice I've color-coded them to match with the prior slide, right? So all the stuff in gray, those are the things that warrant a recalculation of the composite score. Judgments and settlements, agency, bar defense litigation, other qualifying litigation, getting a teach-out notice from your creditor, GE programs, qualifying withdrawal of owner's equity. And then you've got 3 90-10 failure, publicly traded institution triggers, and failing cohort default rates, which fall into that middle category of if this happens, we're not going to recalculate the composite score. You're automatically not financially responsible. And then finally, you've got the discretionary factors and events. Now, the department in the guidance it recently put out did not say anything about at-risk GE programs or failing cohort default rates. And that's because schools don't have to report when these things occur. And the reason they don't have to report is the department already knows, right? Because they have that information. They calculate the cohort default rates. But for all of the other boxes that don't have a blue rim around them, right, for all of those other things, schools have associated reporting requirements, right? And to my knowledge, by the way, and I've put in this request to the department, but I haven't heard back yet, these reporting requirements apply to all institutions. If you're a public institution, you may know that you establish your financial responsibility by virtue of the fact that you are backed by the state. Right, so you don't have the same kind of financial responsibility calculation and approach that private, nonprofit, and for-profit schools have. But there is nothing in the regulation that indicates that public institutions don't still have to report to the department when these triggering events occur. And I haven't seen anything along those lines, and it was not in the guidance. I'm trying to run that to ground. But for now, I think even if you're a public institution, you should assume that you are still required to meet these reporting obligations. Just real quickly so you understand, if you do report one of these triggering events, what happens? So in most cases, you have to report the event to the department. You do have an opportunity to provide evidence that the event is non-material. As applicable, the department may or may not recalculate a composite score. If they do and the projected composite score is less than 1, that's what they consider to be material, and that would be result in a determination that the school is no longer financially responsible. If, because they redid the composite score or otherwise, if you have one of those other events that occurs, either a discretionary event or one of the other automatic events, at any rate, if the department determines you're not financially responsible, then you may still be able to participate, but you would do so under provisional certification, just like schools right now that have a composite score that falls below 1 or maybe for some other reason have been put on provisional certification. You may also be required to post a letter of credit or some other form of surety with the department and comply with cash monitoring restrictions. I do want to emphasize in all cases, schools will have an opportunity to demonstrate that even if a triggering event occurred, that it no longer exists, has been resolved, that you've got insurance to cover it, or as a general matter, that it's not material to the institution. But keep in mind that the department will make that determination after you report the event. And there was a lot of conversation with the department, both during the BDR2 neg reg and the BDR3 neg reg that I participated in, where we said, yeah, but schools are going to have lots and lots of these events, as you'll see, because I'm about to go through them, that occur where we know, let's say there's a settlement, where you have a settlement with a student and you're, Harvard University, and you settle with the student for $1,500. That is clearly not material. Isn't there some way that we could work out a mechanism where Harvard doesn't have to report that to the U.S. Department of Education? Because it's clearly not material, right? And the department ultimately said, we want you to report it anyway, and then we'll decide whether or not it's material on the back end. So one of the things I want to point out, and one of my concerns here to make sure that institutions understand, is you have an obligation to report triggering events even if it is clear on the face of those of the event that it's not material to your bottom line, because there's not a materiality threshold on the front end that obviates the reporting requirement, right? What you have is an opportunity after you report or at the time you report to demonstrate to the department or argue to the department that the event is not material, right? But it doesn't obviate the front end reporting obligation. So let's talk through these reporting obligations. And again, this is for every kind of school in every sector of higher education if you participate in Title IV. First of all, final judgments and settlements. This is the triggering event. An institution is, if an institution is required to pay any debt or incurs any liability arising from a final judgment in a judicial proceeding or from an administrative proceeding or determination or from a settlement. I want to highlight that there is no qualification here regarding the nature of the underlying claim or the litigation or the settlement, right? So at least as of right now, this isn't specific to bar defense claims. If you've got a slip and fall settlement you paid, if you have a sexual misconduct issue and you ended up making a payment, it does not matter. Any settlement or liability, institutions are obligated to report to the U.S. Department of Education, right? And that could be from litigation or from an administrative proceeding. Could be $1,000, could be $500. The thinking here, remember, this is under the financial responsibility framework. And what the department is trying to get at is whether or not an event has occurred at your institution that has required you to pay out some amount that could be material to your financial responsibility. And they don't care what the underlying litigation or allegations may have been. Their concern is the payment and its impact on the institution's financial wherewithal. The reporting time frame, so by May 14th, 2019, 60 days from their announcement on March 15th, by May 14th, 2019, institutions are supposed to notify the department if a qualifying event occurred between the fiscal year end for your most recent annual audit submission and March 15th, 2019. So let's say hypothetically that you have a June 30 fiscal year end. So you right now you're working. You had the June 30, 2018. You were supposed to report and should have reported by December 31, 2018 your most recent audit. If you're a private nonprofit, your A133. If you're a for-profit, your annual Title IV compliance and financial submission. What that means is if the event occurred between June 30, 2018 and the present, right, then you have to notify the department by May 14th, 2019. On a go-forward basis, right, you're supposed to notify the department within 10 days after a payment was required or a liability was incurred. Within 10 days, right? And you're probably going to need to coordinate. If you're in the financial aid office or you're in the finance office, you may not be aware of these obligations, right? Because the litigation may be managed by your general counsel or someone over in legal or an outside law firm. So you're going to have to coordinate closely with whoever is managing litigation settlements to make sure that you satisfy the reporting requirements. Right now, notification should be sent to the email address that's on your screen, and there is no form of notification that has been specified. So the department has not said, at least for financial responsibility triggers, the things I'm going through right now, that you have to provide, claims or pleadings or the settlement documentation. They just indicated that you have to provide them notice. My suggestion would be, the material, concepts here are how much was paid. I guess you could include something along the lines of what it was paid for and about. And then if you are trying to make an argument that it wasn't material, you'll want to probably make that argument at the time you make the notice. We'll be working with clients, of course, if they have things to provide the department on how to fashion these notices. And we may see more out of the department over time about how they want it to look and the information they want to be included, but that was not detailed in the March 15th guidance. So final judgments and settlements is our first category. Agency borrower defense litigation. So here's the event. If the institution is being sued in an action brought on or after July 1st, 2017 by a federal or state authority. So this is government litigation, right? A federal or state authority has brought this action for financial relief on claims related to the making of a direct loan or for enrollment at the school or the provision of educational services, and the suit has been pending for more than 120 days. This is complicated stuff, by the way. The triggering events around litigation and settlements are complicated, and it is lawyer-type stuff. So you're probably going to want to engage with whoever the lawyers are that are managing this for you to try to discern whether or not these triggering events have occurred and to try to understand when your reporting obligation is being triggered. Right? The other thing I want to highlight here is this isn't a settlement or a final determination. This is just the act of being sued. So if you're being sued, even if the litigation's ongoing, there have been no decisions as to whether or not there's liability, what the department is basically saying is, we believe the act of being sued is potentially significant enough for an institution's financial responsibility that we want to know about it, even if the litigation hasn't been resolved yet and there's no decision as to whether or not the institution is liable for any amount. Okay, The reporting time frame, again, by May 14th, 2019, and this is getting very specific. Let it wash over you. You can come back and look at the slides. You can show them to your lawyers later. By May 14th, 2019, a school's supposed to notify the department if this agency bar defense litigation, if you've got qualifying litigation, has occurred after July 1, 2017, has been pending for more than 120 days, and was still pending as of March 15th. Okay? In the future, on a go-forward basis, you're supposed to notify the department within 10 days after you've been served with a complaint, again, by a state or federal agency asserting bar defense style litigation, and 10 days after the suit has been pending for 120 days. My read in the regulation is this is a double notification requirement. Within 10 days after you're served with the complaint and 10 days after the suit has been pending for 120 days. So you have 2 times that you're supposed to notify the department. Notification information is at the bottom of the screen. Qualifying other litigation, and I think this is probably the most complicated one to track. It is also the broadest. So here's the triggering event. If the institution is being sued in an action brought on or after July 1, 2017, that's not agency bar defense litigation. And so let me be really clear. Let's think about that opening and what we're talking about here. We're talking about any other litigation, not bar defense claims. Any other litigation that fits into one of the categories I'm about to describe. So if you're a large private nonprofit or a flagship state institution, we're talking about reporting to the department all of your litigation that fits into this box. So the institution is being sued in an action brought on or after July 1st, 2017. That's not agency BDR litigation, right? So it's not from an agency. It's not about bar defense. And the school has filed a motion for summary judgment or summary disposition, and that motion has been denied, or the court has issued an order reserving judgment on the motion, or the institution has not filed a motion for summary judgment or summary disposition by the deadline set for such motions by the court or agreement of the parties, or if the court did not set a deadline for filing a motion for summary judgment and the institution did not file such a motion, the court has set a pretrial conference date or trial date, and the case is pending on the earlier of those 2 dates. So just to be clear, we're talking about all litigation. There's no materiality threshold. It does not matter what the basis of the litigation is. We're just talking about all other litigation. If your school is being sued in an action brought on or after July 1, 2017, and one of these other 3 conditions has been met, that's the triggering event. What's the reporting time frame? It's sort of equally complicated. By May 14, 2019, you're supposed to notify the department if this qualifying other litigation occurred after July 1, 2017 and has been pending for more than 120 days and was still pending as of March 15, 2019. In the future, the obligation is to notify the department within 10 days after the institution served with the complaint, 10 days after the court sets the date for the earliest of the triggering events, right, provided that if the deadline is set by procedural rules, notice of the applicable deadline must be included with the notice of the service of the complaint. And, so again, we're talking about 3 separate reporting obligations here, and 10 days after the earliest of the applicable events occurs. This is, if your head is spinning, that's okay. You don't have to remember all of this right now. What I would tell you is, if you're an institution and you have outstanding litigation, then what you need to do is you need to sit down with your lawyers and you need to grab these slides or grab the department's guidance and think through this very carefully. Don't try to figure it all right now. Just understand, though, that you have reporting obligations, and those reporting obligations aren't exclusive to litigation for bar defense claims. Right? Those reporting obligations, because this, again, is under the financial responsibility framework. What the department's trying to get at is, are you at risk? Are there things happening at your institution that could impact your financial wherewithal? And they want lots of information. So what they're asking for is information about your settlements, about judgments against you, about state and agency litigation, and also about any other litigation that satisfies one of these requirements. So if you've got anything going on in those spaces, or have since July 1, 2017, my recommendation, again, is that you get with your lawyers and you sit down and figure out what may have been triggered and what your reporting obligations may be. Okay, so let's move on from litigation. The good news is I really do think that among the reporting obligations and the guidance, those are probably the most complicated to figure out. Okay, everything else I think is a little more straightforward. I say that, this one is a little complicated too, but mostly I think it gets easier from here on out. Okay, a creditor teach-out notice. I want to draw a distinction here because there is a separate reporting requirement that I'm going to talk about a little later that deals with creditor and state actions. This is an odd requirement, and it's very specific to you receiving a communication or notice from your creditor that you are required to put together a teach-out plan. But it is broader than you might think. So here's the triggering event. If an institution is notified by its accrediting agency that it must submit a teach-out plan for a reason described in 602-24C1 that covers the closing of the institution or any of its branches or additional locations. Here's the thing. That reference to 602-24C1, that's in the portion of the regulations that tells accreditors what they have to do, right? It's in that section of the regs where the department talks about what accreditors have to do if they want to be recognized by the U.S. Department of Education. And one of the things that an accreditor is required to do is in certain circumstances, it's required to send a notice to the institution and require the institution in turn to provide a teach-out plan. Okay, so accreditors have to do this. If they're not doing it, they're not complying with their own obligations under the regulation. Let's just assume that they're going to send you this notice. You might be surprised when this notice is required. And my expectation as accreditors, as they become aware, if they are not already, that this reporting obligation now exists in the law, are going to get better about sending out these notices, right? So an accreditor is supposed to send you a notice that a teach-out plan is required if any one of these things occurs. If the department initiates an emergency action or FLST proceeding, okay, well, that's a big deal. That's understandable. If the accreditor acts to withdraw, terminate, or suspend accreditation, also a really big deal. But check out this third bullet. If the institution notifies the accreditor that it intends to cease operations entirely or close the location. Okay, so let's be clear. If you're a private nonprofit and you have locations on military bases around the country, right, or maybe you've got international locations, and markets change or the military base decides to move in a different, whatever happens, and you say, hey, we're going to close down that additional location. We're going to wind it down responsibly, right? That's not a problem. Okay, well, then your accreditor, when you make that determination, is supposed to send you a notice saying you have to provide a teach-out plan. And that is now a triggering event. And you have to report that to the U.S. Department of Education. Now, it may not be material, and you may be able to demonstrate that easily to the department, but please be aware that you have a reporting requirement now that has been triggered, and you want to make sure to report that information to the feds. Finally, if a state agency notifies the accreditor that an institution's license or legal authorization to provide an educational program has been or will be revoked. Okay, so if any of these things occur, some of them are understandably sort of major events, but a couple of them are surprisingly could be just routine business. If any of them occur, then the accreditor is supposed to send you a notice that you are required to supply a teach-out plan. And when you get that notice, that's the triggering event. Interestingly enough, the reporting is tied to the notice, not whatever prompted the notice, right? So it's not the closing of the location that requires that you report to the department. It's literally when you got the notice from the accreditor that you have to supply a teach-out plan. So by May 14th, 2019, 60 days, you're supposed to notify the department if the triggering event occurred. In other words, if you got a notice from your accreditor between the fiscal year end for your institution's most recent annual audit submission and March 15th, 2019. In the future, on a go-forward basis, you're supposed to notify the department within 10 days after the institution is notified by its accrediting agency that it must submit a teach-out plan. Again, the notices are done by email for all of these, and there is no specific form of notice that has been articulated. Withdrawal of equity. So this one does just apply to for-profit institutions. For a proprietary institution, if you've already got a composite score that's less than 1.5, any withdrawal of owner's equity from the institution by any means is supposed to be reported unless the transfer is to an entity included in the affiliated entity group or whose basis the institution's composite score was calculated. I will also say there's an allowance. I don't cover it here. You can demonstrate to the department if the withdrawal related to paying taxes as well. So if you're a proprietary institution and you think you're covered by this, you will want to pay a little more attention to the rule and determine whether or not you need to report and whether you should be providing additional information to the department. Again, by May 14th, 2019, you're supposed to notify the department if a withdrawal occurred between the fiscal year end for your school's most recent annual audit submission and March 15th. By the way, I mean, what's the basis for tying the reporting requirement to your audit? It's because for certain of these, the department, the thinking is, well, if it occurred prior to the end of your last audited fiscal year, it's already been sort of included and accounted for in the audit itself. And we're running a composite score, and so we kind of already know about it and know about whether it's material or not. In the future, on a go-forward basis, you're supposed to notify the department within 10 days after such withdrawal is made. 90-10 failure, also just for proprietary institutions. For proprietary institutions, composite score is less than 1.5. Oh, this is a, I apologize, this is a copied slide that didn't get fixed, but it's easy to tell you what. The triggering event here is if the institution in its annual audited financial statements, if it didn't satisfy the 90-10 rule. In other words, if your Title IV revenue exceeded 90%, then you're required to report that to the department. And my apologies for the slide. We'll get that fixed. The reporting time frame, by May 14th, 2019, you're supposed to notify the department if you failed 90-10 for any fiscal year beginning on or after July 1, 2017. This notification should be redundant. And why do I say that? Because you are already required to report a 90-10 failure to the department within 45 days under 668-28C3. So this is 100% a redundant notification requirement, but it is redundant. I mean, the department, for whatever reason, is saying we also want you to send a notification to this specific email address. So just keep in mind, if you have failed 90-10 for a year, you need to be reporting that to the department within 45 days at this email address. Publicly traded schools. There are some specific triggering events for publicly traded schools. We don't have many on the line today, so I'm just going to note that they're in the slides. If you are a publicly traded institution and certain events occur with the SEC, then you're required to report those. Again, I'll also remind that this is not an event that prompts a recalculation of a composite score. This is one that is automatically considered to render the school not financially responsible, right? And here are the reporting time frames. If you were subject to one of those triggers between July 2017 and the present, and also the going forward reporting requirement. State or creditor action. So remember, this, and again, we're back to a trigger that applies to all institutions, and this trigger is separate from that teach out notice trigger that I mentioned earlier, okay? So here's the triggering event. If the institution is cited by a state licensing or authorizing agency for failing state or agency requirements, that's pretty broad if you think about it. So if you get some indication from your state authorizing entity, right, that you failed a state or agency requirement, it's hard to know. I mean, if they do a routine audit and you get some sort of response saying, hey, you failed on these 3 points, whether that's covered, we don't have guidance yet from the department that makes clear. My guess is the department isn't going to want to draw a line because, again, their general approach has been, we're not putting together a materiality standard on the front end. We want you to report everything, and we'll figure out on the back end whether we think it's material or not. Or the institution is or was placed on probation or issued a show cause order or placed on an accreditation status that's equivalent, and you'll have to decide what that means because, again, this is the regulatory language. The department really doesn't articulate here or in the guidance what they mean by, quote, an action that would pose an equivalent or greater risk to, say, show cause or probation. But if you are an institution that's been placed on probation or had a show cause order or something similar by its accrediting agency for failing to meet one or more of the agency standards. So if either one of these things occurs, you have a reporting obligation. Now remember, again, you'll have an opportunity to demonstrate to the department that this action is not material to the institution's financial wherewithal, but it does not obviate the front-end reporting requirement. Okay. What's the reporting time frame? So by May 14th, 2019, you're supposed to notify the department if any qualifying events, so show cause order, probation, notice from the state authorizing agency that you don't comply with the requirements, if any of those things happen after July 2017, unless they've been resolved. Okay, so that's good news. So if you did get some sort of routine audit or something, said you're out of compliance, and you responded and the agency wrote back and said, great, now you're in compliance, you don't have to report that. But if it is unresolved as of March 15, 2019, you got 60 days to let the department know. In the future, you have to notify the department within 10 days after you're cited for violating a state or agency requirement, or 10 days after the institution's accrediting agency places the institution on whatever the triggering status would be, i.e. probation or show cause. All right. I apologize. Give me just a second here. I had my slides glitched on me. See if I can get them back. All right, here we go. All right, so violation of a loan agreement. If the institution, and this could apply to institutions in various sectors, if the institution violated a provision or requirement in a loan agreement and as provided under the terms of a security or loan agreement between the school and the creditor, a monetary and non-monetary default or delinquency event occurs, and then there's more to it. I won't read the whole thing, but the point is if you've got loan or credit agreements outstanding and you believe that you may have violated a provision of those requirements, you may have a reporting obligation to the department. Okay, there is some opportunity to show in those cases where a violation was cured. You can demonstrate that to the department, and in some instances, if it was cured, there's a provision you would still need to provide it to the department, but in addition to showing it's not material, it would obviate potentially the need to report. Okay, and again, I'm not going into all of that. This is one of those particular areas where the rule itself has some additional discussion around what constitutes a violation of a loan agreement. The main point I want to make here is, as indicated on the prior slide, if since July 1, 2017, you have, or potentially you believe you have been in violation of or default under a credit or loan agreement, you potentially have a reporting obligation. By May 14, 2019, you need to notify the department again of any qualifying event. In this case would be that violation that occurred after July 1, 2017. In the future, you're supposed to notify the department within 10 days after a loan violation occurs. The creditor waives the violation, or the creditor imposes sanctions or penalties in exchange or as a result of the waiver. So again, this is an or, but my read on this is that you're supposed to supply the department with a notification at each stage or in each time one of these events occurs. That certainly would be the conservative approach. Okay. So that's the end of the financial responsibility reporting requirements. And I highlight that because I'm about to talk you through a couple of additional requirements that I will call submission requirements because the department expects more than just a notice in this case. But I also want to highlight that these requirements are not under the financial responsibility section. They are under, and I'll talk through this in a minute, but they are conditions of your continued participation in the federal financial aid program. So even though you may have an event of litigation where you have a notice requirement under the financial responsibility section we just talked about, and then you're required to submit arbitral or judicial records, please keep in mind that, at least from a regulatory standpoint, these requirements spring from two different sections of the regulation, and they are slightly different. One isn't the notice requirement, right, and there's no prescribed form. You're not submitting additional documentation. The other that I'm about to walk you through actually requires a submission of documentation to the department. Okay. So you have, if you participate in the federal financial aid programs, a PPA, right, a program participation agreement. Maybe it's provisional, maybe it's temporary, but it's a PPA, right? And part of your PPA, sort of incorporated into it, is your direct loan participation agreement. So they're kind of one and the same. In the regulations, this is under 34 CFR 685-300. That's the part in the regulations that requires institutions to enter into this DL agreement, direct loan agreement, if they want to participate in the federal financial aid programs. So what the department did when they wanted to address pre-dispute arbitration clauses and class action waivers, but also get at some of these other ideas I'm about to go through, they amended the part of the regulation that dictates what's in the direct loan agreement. Right? So they revised 685-300 to condition a school's continued participation in the direct loan programs on their acceptance, meaning the school's acceptance, of certain terms concerning dispute resolution. And that's where this comes from. Only BDR claims are covered, first of all, and that's really important. So remember, previously when we were under financial responsibility, there were lots of different kinds of claims that we were concerned with, right? All litigation, all judgments, and I've said this a couple of times, but I'll emphasize it again. That's because the real concern there was about the school's financial wherewithal. Here, the department is focused more specifically on arbitral records, judicial records, where the underlying claim is a borrower defense claim. So again, these new requirements only relate to student claims or complaints that are or could be asserted as a bar defense claim. This means claims or complaints based on acts or omissions of the school that relate to the making of a federal loan or the provision of educational services for which the loan was provided. The department has repeatedly indicated that this would exclude, for example, personal injury tort claims or sexual or racial harassment claims. Based on the discussion we had in the BDR3 neg reg and in some of the language included in their first proposed version of that rule, and again, this is not law, but just based on the discussion, the current administration seemed to suggest that they might also consider the following to be excluded from a bar defense claim: the general quality of the student's education or the reasonableness of an educator's conduct, so what you might have traditionally thought of as like an education malpractice claim, academic disputes and disciplinary matters, and any claim that's not directly and clearly related to the making of the loan or the provision of educational services, right? Why is it important to understand what is a BDR claim and what's not? So, well, again, we just indicated these requirements only apply when it's a BDR claim, right? So if you think that it is not a BDR claim and you're going to have to make a decision as an institution, that may mean that you don't have to submit the judicial or arbitral records. But if you think the underlying claim is a bar defense claim, that's what would trigger, in this case, your submission obligation. Now, ultimately, the department has said, and it's in the regulation, that whether or not something's a bar defense claim would be decided by the court. Right? So if somebody brings a lawsuit against you and they're trying to say that this is a bar defense claim, and as a consequence you can't compel it to arbitration or whatever, for whatever reason, right? If the court is considering this issue or whether or not it's a bar defense claim is germane, okay, then the court will make that decision. But here's the thing, the submission requirements that I'm about to talk about occur probably in most cases before a court would ever consider that question, right? In other words, you've got a certain amount of time after a claim comes in and the litigation is initiated to submit the documentation to the department, and a court may not be anywhere close to deciding whether or not the underlying claim is a bar defense claim. So you as an institution are going to have to make that decision and decide whether or not you think these are records that need to be submitted to the department. The other thing is you probably want to be mindful. I mean, my expectation as a practical approach is folks will be conservative, but you will also, when you submit that information, probably want to say to the department, we're submitting this, but it has not yet been determined whether or not this is indeed a bar defense claim by the court. But out of abundance of caution, we're providing it to the department in satisfaction of, 685, 300E3 or what have you. Okay, so submission of judicial records. A school must submit a copy of the following records to the department for any BDR claim, right, any lawsuit where the underlying claim is a bar defense claim, by the school against a student or against the school by any party. So it's interesting that this language, by the school, I'm not sure how frequently a school would be suing, although maybe if there was a counterclaim of some sort. But the real focus here is if a student, right, sues the institution. Okay, then you have an obligation to report the judicial records if, and by that, let's see, school must submit a copy of the following records. So you have to submit the complaint and any counterclaim, any dispositive motion filed by party to the suit, and the ruling on any dispositive motion and the judgment issued by the court. By the way, I also want to emphasize again, this obligation falls on all institutions of higher education, and I will also highlight that it has nothing to do with whether or not you have a pre-dispute arbitration clause or class action waiver in a contract with a student or whether you use enrollment agreements, etc. This is just a standalone requirement. So if you have a student who sues the institution and the underlying claim ostensibly could be a bar defense claim, then you have to submit these records to the U.S. Department of Education. Okay, the reporting time frame. By June 13th, 2019, so in this case you got 90 days from when they put out the guidance, you're supposed to submit judicial records to the department for any lawsuit based on a BDR claim that was pending as of July 1st, 2017 or initiated after July 1st, 2017. In the future, on a go-forward basis, you're supposed to submit the judicial records within 30 days of filing or receipt as applicable of the complaint, answer a dispositive motion, and within 30 days of receipt of any ruling on a dispositive motion or a final judgment. Okay, let's talk about arbitral records. So it's a very similar framework, but the particulars are a little different. You need to make sure to review these, again, with your lawyers if you think you've got anything that might fall into this bucket. The school must submit a copy of the following records to the department for any BDR claim filed in arbitration by or against the school. By or against the school. So you got the claim and the counterclaim, the arbitration agreement filed with the arbitrator, judgment or award. If the arbitrator refuses to administer or dismisses a claim, any communication along those lines, and any communication the school receives from the arbiter that a pre-dispute agreement regarding educational services provided by the school does not comply with the administrator's fairness principles, rules, or similar requirements. Okay, so again, you don't have to memorize all this right now, but if you've got something that might fit into this bucket, you need to sit down with your lawyers and decide whether or not you have a reporting requirement. The reporting time frame for arbitral records by June 13, 2019, again, 90 days. You have to submit them to the department for any arbitration based on a BDR claim that was pending as of July 1, 2017 or initiated after July 1, 2017. So even if it started before July 1, 2017, if it was still pending on that date, it's covered. In the future, you have to submit arbitral records within 60 days. So it's interesting. The judicial records, 30 days. The arbitral records within 60 days of the filing or one of the qualifying events occurring. Okay, and those, by the way, I also want to highlight the judicial records and arbitral records go to a different email address from the financial responsibility notices. At the bottom, you'll see a copy of these records are supposed to be sent to borrowerdefense@ed.gov. Internal dispute process. This is the last piece before we get to pre-dispute arbitration agreements and class action waivers. So schools are prohibited from requiring students to first seek resolution of borrower defense style claims through an internal process. In other words, students have to be permitted to present a BDR claim directly to an accredited or appropriate government agency. So if you've got a grievance process right now that says any grievance has to first go through our process, you need to amend that. I'll also just offer, I typically advise my clients, I would not include in your materials that students are for some reason or somehow prohibited from going directly to, your state regulator or your accreditor. As a general matter, if a student wants to take a complaint directly to one of those agencies, not only do you want to acknowledge that they can, but as a practical matter, you might as well because they're going to do it, right? I mean, there's no way to stop that. So why have a policy that suggests that they can't do it? My suggestion would be just to make sure you've revised your policy in the least to comply with this requirement. All right, so pre-dispute arbitration clauses and class action waivers. I know this is primarily an issue for proprietary and career schools that include these types of clauses and waivers in their enrollment agreements. Most private nonprofits and public institutions do not use enrollment agreements, and many career schools don't include these types of clauses or waivers, but some do. So this portion of the presentation, we want to focus on those of you that do. Institutions that previously used pre-dispute arb clauses or class action waivers that cover borrower defense claims or basically cover all claims have two options under this rule. So if you've currently got a pre-dispute arbitration clause and or class action waiver in an enrollment agreement, and it just covers all claims that might be brought by a student, typically that's how it would be written, you've got two options. The first is, and right now, by the way, I'm talking about, this is really important, I'm talking about for existing agreements. For all those agreements that you've already signed that include these types of clauses and waivers, you've got two options. The first is you can go back and amend all those prior agreements, right, which is almost certainly impractical, and I don't think anyone, including the department, really expects you to do. The second is that you can provide notice that you will not enforce those clauses and waivers as they were with regard to BDR claims or as they pertain to BDR claims. The department recognizes in the guidance that providing notice is the more practical and likely approach. They have some language to that effect, right? So what are we talking about in terms of notice? You have to provide notice to direct loan recipients. And by the way, this is an important point too. This only, because it's embedded in the direct loan agreement, it only applies to students who took out direct loans. So if you have a student who paid cash, who didn't have any direct loans, even if they had a Pell Grant but no direct loans, then this requirement doesn't apply. Now, operationally, it may be easier for you to just put the notice process in place and not worry about that. But keep in mind that this is specific to folks who receive direct loans. So institutions have to provide notice to direct loan recipients, no later than at the point of exit counseling or the date on which the institution files its initial response to a demand for arbitration or service of a complaint from a student who has not already received a notice or amended agreement. So let's just take a step back and think about this for a minute. So what the department is saying is, look, for all those agreements you already signed, if you've got enrollment agreements that include these clauses and waivers, right, we're not saying that you have to actually go back and amend all of them. I mean, you could. That's one option, right? Nor are we saying that you have to call up all of your former students or borrowers, I should say, anyone who signed one of those agreements, and give them all this notice. Really what we're saying is this. For the folks who are still enrolled and have not yet got to exit counseling, you need to provide them with the notice, right? And you ought to do it before they get to exit counseling. I think that's the conservative read on this, and that's probably operationally the easiest way to get the job done. For everyone else who's already graduated or withdrawn or already passed exit loan counseling, you can essentially give them notice when a complaint comes up. So if they sue you, are they just to be clear, you know, if you get an initial, if you're responding to an initial demand for arbitration or service of a complaint, that's when you provide the notice. Otherwise, you don't have to go out and provide everyone that notice, right? So if they're already gone, if they're past exit loan counseling, if they've withdrawn, if they're a former graduate who signed one of these agreements, you don't have to hunt them all down and give them a notice, right? But what you have to be prepared to do is to provide them a notice if you get served with a complaint or a demand for arbitration. Right? Now, I'm not your lawyer. Oh, well, if I am, you should call me. But this is not legal advice, right? This is informational. If you think you are in one of these situations, or if you're trying to figure out how to approach this, you should talk to your lawyers or your compliance experts and review it and come to your own conclusions, right? But from my perspective in reading the rule, that's where we land. Institutions must implement their new notice processes by May 14th, 2019. So that doesn't mean you have to, remember, give every former student or graduate, right, the notice by that day. What you have to do is by May 14th, 60 days from now, you've got to have your process in place, right? So for the folks who aren't yet to exit loan counseling, you probably want to have the process in place to get them the notices. And then for everyone else who's already gone, you need to be prepared and have your process in place and your notice written up, right, so that if you get served with a complaint or a demand for arbitration, you're ready to go. The department has not created a notice form. So they haven't produced some sort of document. They say this is what you're supposed to hand. But they have said whatever you give them, this notice, whatever it looks like, it has to include the exact language on the following two slides. I'm not going to read this verbatim, but I wanted to include it here. So if you've got pre-dispute arbitration clauses that were in those existing agreements, you have to, in your notice, give them this exact language, right? And if those pre-existing agreements that are already signed have a class action waiver, whatever notice that you're giving out has to include this specific paragraph. And that's in the department's guidance. It's also straight out of the regs. By the way, I'll highlight at the bottom of all these slides, we've included citations for you if you want to go out and actually look at the regulatory language. Okay, what about ongoing arbitrations? This is complicated stuff, and I'm just going to offer right up front, if you have an ongoing arbitration, you need to talk to your attorneys and make them aware of this guidance and figure out what you should do, okay? This is out of the department's guidance. They say the unenforceability of pre-dispute arbitration clauses and class action waivers applies to any arbitration proceeding that was ongoing and not final as of March 15th, 2019. So on the day they put out their guidance, if you had an ongoing arbitration proceeding, the unenforceability clauses, the stuff we just went through, applies. If it was ongoing and not final, if it concerns a bar defense claim and involves a direct loan recipient. So it has to hit on all of those. And was initiated pursuant to a pre-dispute arbitration agreement. Why do I include that last clause? It is possible to enter into an arbitration agreement with someone after a dispute arises, right? I mean, someone could bring up a complaint and you could say, hey, will you agree to go to arbitration? They say, yeah, and you sign an arbitration agreement. That's okay. I want to be really clear that all of this stuff we're talking about involve clauses that require pre-dispute arbitration clauses. In other words, you and the student have agreed before any dispute arose that it would go to arbitration. So that's why I say if you had an ongoing arbitration as of March 15th that wasn't resolved, and it concerns a BDR claim, involves a DL recipient, and was initiated pursuant to a pre-dispute arbitration agreement, then it's covered, okay? In other words, you have an obligation with regard to the unenforceability provisions. For any such arbitration, institutions are required to provide students with applicable notice of the unenforceability of those clauses by March 25th, 2019. Now that date's already passed. It was Monday, right? So if you had ongoing arbitration that met all these requirements on this slide, and you have not yet provided notice to the student that you won't enforce the class action waiver or the pre-dispute arbitration clause, you need to get with your attorneys and talk about whether you should be doing that or not, right? The other thing I'll also offer, the department seems to indicate that arbitrations that concluded prior to October 16, 2018 are unaffected, while those that concluded after October 26, 2018. So this is an arbitration that's already done, but if it was concluded after October 16, 2018, it appears that it may be impacted by this rule. You should consult counsel. Again, if you had an arbitration that concluded after October 16, 2018, you should talk to them about the enforceability of that arbitration and how it ended up. Let's talk about future agreements. So, and this is easier, right? We're not talking about all those existing agreements that were already signed that included the pre-dispute arbitration waivers, clauses and the class action waivers. We're talking about what you're doing on a go-forward basis. This is easier. So let me be real clear. If you have a pre-dispute arbitration clause or a class action waiver in your enrollment agreement right now, and it covers everything, and you feel like you want to keep it in, because some schools don't, but if you've talked to your counsel, you feel like it's a valuable thing to have in your enrollment agreement and it's something that should be there, you can leave it in. Let me say that again. You can leave it in. But if you do, you have to augment it to include specific language from the department saying that you will not enforce that clause or that waiver respectively if the underlying claim is a bar defense claim, right, by a direct loan recipient, okay? And the department has very specific language. So let me say that again. You don't have to take the pre-dispute arbitration clause or the class action waiver out of the enrollment agreement. What you have to do is amend your enrollment agreement to make clear that you won't enforce those provisions if the underlying claim is a bar defense claim and the person bringing it is a direct loan recipient, right? And this could be important because if someone brings a slip and fall claim against your institution, right, or sexual misconduct or something like that that's not a bar defense claim, then your pre-dispute arbitration clause and class action waivers would still apply, right? And there could be value there. And your attorneys can talk to you about whether they think there's value there or not. If you continue to use them, though, you have to include in the enrollment agreement the exact language, and I've got the regulatory sites here at the bottom of the page, and then I've laid it out for you again. So here it is. This is if you've got a pre-dispute arbitration clause and you want to keep it, and then the next slide is if you've got a class action waiver and you want to keep it. Okay, so all of this having been said, what I've been talking about is what the department has indicated schools have to do in their guidance and based on the law. But I understand a lot of folks who may have these clauses and waivers probably have questions around the challenges that have been made, ongoing litigation, and why is it that the department is requiring this or can require this now when it seems like previously they weren't. And for that conversation, and with 13 minutes, I did better than I thought I would, I'm going to turn it over to my partner, Jeff Fink.
Great. Well, good afternoon, everybody. As Aaron mentioned, the validity of the prohibition on pre-dispute arbitration and class action bans, it's not settled yet. There is a lawsuit pending in federal court in D.C. by the California Association of Private Post-Secondary Schools against the Department of Education, challenging the validity of the BDR, but only as to the extent it affects arbitration. And it's a highly contested case. There are a lot of entities, states, attorneys general, and others who are afraid that the department would just roll over and not defend the arbitration ban vigorously, and so they have intervened. So there are a lot of parties lined up in this case, and it's a vigorous fight pending. The status of that litigation, both sides have teed up what they call summary judgment motions, which is very common when you're challenging an agency rule, because typically the validity of the rule is just, it's a question of law that a court can determine. So the papers have been filed. They've been started, and there's still some more papers that will be filed. And then after that, it's hard to predict how quickly the court's going to take to rule on the validity of the arbitration ban. I think it's fair to say that it's virtually impossible, very unlikely that the court will issue a ruling before your obligation to make amendments to arbitration agreements and to provide notices to students before that's triggered. It's just not going to happen within the next 60 days, and unfortunately. So what do you do with that? Well, suggestion we have here is that, yes, you have to include these amendments to your agreements, or you have to issue the notices. One way that you could hedge on this, and now you have to use the exact language that the department has mandated, but you could add a little additional language after the end, just stating that we make the preceding agreement, and that's the agreements the department's requiring you to make, either in the agreement or in the notices. You could say something along the lines that we make the preceding agreement only to the extent required by a valid regulation issued by the Department of Education, and something along the lines that we're only making this agreement so long as basically we're required to do so by the Department of Education. In effect, you're saying we're doing this under protest. I mean, you can't really use the words protest, I don't think, but you could say that we're only doing this on the condition that we're required to do so by the Department of Education. So that's one way you can try to preserve your rights, because the challenge to the rule, it's not going to get resolved before you have to do stuff. Now, we've heard some people suggest and had some discussions, well, what's the risk here if you don't comply with this? And you just say, well, this is a bad rule, I'm going to wait it out. You could take that tact. We really highly do not recommend you do that. There may be no enforcement by the current Department of Education. I mean, they've signaled, even in the litigation over the rule in federal court in D.C., they signaled that, hey, this isn't something we would do if we had to start all over again. And there's a lot of indications in there that in the future they might get rid of the anti-arbitration ban. But for now, it's the rule, and they're at least ostensibly on paper, they said they're going to enforce it. Now, whether they will or not, well, the only time will tell. The problem you have, though, is if they do enforce it, or let's say you get a new sheriff in town come 2021, and you haven't been complying with this, you've jeopardized your entire participation in the Title IV program, which is, I mean, in my view, it's not worth it just to have the benefit of arbitration, given how dependent most institutions are on Title IV participation for their schools. So there is that option out there. We don't recommend it. Even then, the game is not over in terms of arbitration. As Aaron said, there are still claims that can be, even under the department's anti-arbitration rule, there are still claims that you can include in your arbitration agreement. And I think there are still some arguments here that could be made that claims that the department thinks you are required to litigate and can't force arbitration. I think there are some arguments you still could make in a court to suggest that there's a lot more that should be shifted to arbitration than what the department thinks should be. The department, I think, has this view that as long as there's any hook to the claim that involves any part, a direct loan, you've got to litigate the entire claim. You can't force the student into arbitration. I think there are arguments to be made, given the wording of the regulation, that the only part that can stay in litigation and can't be forced into arbitration is the claim to the extent it applies to the direct loan. So if you have a student with a direct loan of, say, $10,000, but they come in and say, I'm suing you for wrongful actions, breach of contract, I want $100,000, I want punitive damages. Even though there's a direct loan involved, I think there's a good argument to be made that everything else beyond the $10,000 claim and relating to the direct loan, everything else has to go into arbitration. Now, it's hard to say whether a court will adopt that or not, but I think it's an argument worth pursuing. If you get a judge who's inclined, doesn't like what the Department of Education is doing, doesn't think this is kosher with the Federal Arbitration Act, I could see a judge buying that argument and pushing off most all of the students' complaint into arbitration. So that's a possibility there. So we got that, and then the other argument too is that, okay, well, some aspect of the student's claims can go to arbitration, even if some of them have to go to litigation. A lot of case law out there, and in this case, that's just what happens is you're going to have parallel proceedings. You're going to have an arbitration of the claims subject to arbitration, and you're going to have litigation of the claims that don't have to go to arbitration. That's required by the U.S. Supreme Court. It said that's just a function of the Federal Arbitration Act. What happens, though, when you have these parallel proceedings, and there's a lot of case law to suggest this, is a lot of times the courts will stay the litigation, let the arbitration go forward, see what happens in that, and then you come back and you have an argument that what happened in the arbitration is binding in the litigation. So even if there's a borrower defense claim here, if you can get that dispute, at least part of the dispute, pushed into arbitration, you get a favorable ruling in the arbitration, you could come back and effectively defeat the borrower defense claim in court with the outcome of the arbitration. Now, none of this is guaranteed. This is very unsettled, but there are arguments to be made. So just because we have this borrower defense regulation in effect now, we've got anti-arbitration rules in place, doesn't necessarily mean you have to give up on your arbitration clauses altogether. On the other hand, you may decide at this point, is it really worth it to have the arbitration clause? Do I really want to spend the money fighting both in arbitration and litigation? Fighting in court as to what has to be arbitrated and what has to stay in court, you may decide, well, it's just not worth it anymore. But I throw these thoughts out there in case you're one who wants to fight this and wants to keep your arbitration clause in effect as much as you can. With that, those are my thoughts on the anti-arbitration rule, the status of it, and what can be done as some reactive measures. And with that, I'll turn it back over to Aaron.
Thanks, Jeff. And I'll just echo what Jeff said. I mean, we're not recommending that you do or do not pursue any one course. I think what we want to highlight is there's some nuances here. And if you're an institution that uses these clauses or waivers, you should talk with your counsel about whether you want to continue doing that, and if you do, how you want to go about it. Because, again, there's a lot of nuance. The other thing I'll just add, in addition to the risk, if for some reason you should decide not to enforce this, which I agree wholeheartedly with Jeff, I think would be a poor idea. But if for some reason you said we're going to keep our clauses, we're not going to include the language that the department is requiring us to include, not only do you bear the risk of a future administration, but also keep in mind in many states there are attorney generals and plaintiffs' attorneys and others who would probably jump on that pretty quickly and say that you are intentionally not complying with federal law, and that could create additional problems or complications for you as well. So just a lot to think about. Here at the very end, I want to move on. There was just a little bit more in the guidance. You all who are familiar with the sort of breadth of the bar defense rule, and you'll recall the slide I had earlier that sort of laid out all the different components of it. There were a couple other things. One, and I'll take these actually in reverse of the way they're titled here. One is the financial protection disclosures. So there's an obligation in the law, and this was an obligation for all types of institutions, not exclusive to for-profit institutions, that if you have certain of those triggers that occur, those financial responsibility triggers or actions, that you have to provide notice to your students and potentially to the public that has happened. Separately, there was a requirement in the law. Initially, in the proposed rule in 2016, the department had come up with a brand new, I think it's the third or fourth federal repayment rate. And then after the comments, they said, okay, well, we're going to use existing repayment rate methodology, but we're going to attach a new disclosure requirement to schools that are failing under that repayment rate. So in the guidance, the department essentially punted on both of these. So they said, with regard to the repayment rate warnings, we'll let you know in a future Federal Register how that's going to work. And with regard to financial protection disclosures, you don't have to make any as of right now, and we will communicate with you in the future about what you need to do. So again, they punted on both of those. 128, not bad. So just real quickly, I always like to highlight, we have our higher education webinar series. This is not part of that. This was a special one-off to talk about the department's guidance, but it just so happens that tomorrow is our next regularly scheduled webinar in our series. You'll see here a March 2019 Intellectual Property Primer for Institutions, and I mentioned that earlier. If you'd like to be part of the series, sign up's free. All of these are free. They're also all available on demand. All the higher ed webinar series, with very rare exception, are also good for continuing continuing legal education if you're an attorney out there. This, in the deck, when you get this, you'll see the underlined ones that have gone before. You can click on those. Those are hyperlinked to the prior presentations, and you can listen to them at your leisure. Here's just a screenshot of where all our webinars are housed on demand. We also have our blog that we do, Regulation, where we talk about lots of federal financial aid and other federal policy, higher education type issues. So with all of that being said, I'm going to pull up the questions and answers here. Well, so far they're just questions, and we'll see if we can supply any answers. Let's see here. So, to what extent, if any, do the bar defense regulations apply to claims of identity theft where a third party used another's personal information to obtain financial aid? Will the department seek recovery from the institution? I mean, off the top of my head, I'm not sure I would expect the bar defense framework to apply to an act or omission of a third party, right? Because the whole idea is you're asserting a defense based on an act or omission of the institution. My experience with these sort of identity theft and fraud rings is that the department or the IRS or the IG or others may seek assistance from the institution in prosecuting the fraud ring. I've not personally seen examples where an institution is being held accountable for fraud or identity theft perpetrated by a third party. I mean, I'm not to suggest that's an impossible scenario for some reason, but that, I don't think the bar defense framework is really designed to get at that. You know, I will offer under, say, the financial responsibility framework that we talked about. I mean, ostensibly, if an institution were somehow the subject of some sort of fraud or identity theft by a third party, but it resulted in a significant financial impact on the institution, you know, ultimately you might have to report that to the department, or it might be taken into account in your annual financial statements. But that seems pretty far afield from the question. Let's see here. Let me go back. Okay. Regarding 90-10 failure, is that requirement related to a second year below 90-10, or does 1 year of failure under 90-10 result in the having to report? It's a single year. If you fail 90-10, even for a first time, you're supposed to report that to the department, and that automatically implicates financial responsibility. That's part of the design of the regulation. Now, remember, you have an opportunity to try to argue to the department in all circumstances that it's not material. But I do believe that is an obligation that springs even if it's just the first year. Let's see. If it is an adjustment of tuition for an issue, is that considered a payment of liability? Oh, interesting. So we're talking about settlements and judgments. If you were trying to resolve a student complaint and you adjusted the student's tuition, you know, I haven't given a lot of thought to that, and you should probably talk to your counsel, but my gut reaction is that no, that is neither a settlement or a judgment. Now, if you have a former student and you enter into some sort of release, I think there is another question around whether or not, if that release is a formal agreement, you know, whether or not that release somehow constitutes a settlement between you and the student. I don't necessarily have a final opinion on that, but it's probably something you want to think about. Let's see here. Let me see. Give me a second, guys. I apologize. My screen is a little wonky. I'm just trying to advance through the next question. You know, I'm Jeff, can you see the questions? I'm having a little trouble with my screen. I was wondering if you or, let's see. Oh, here you go. I got it back. but I may have to ask one of you guys to help moderate the questions here because I'm having a little issue on the screen. Okay, triggering event. The institution is required to pay any debt or incurs any liability. Is this a payment only to a student? No, I don't believe that it is. That is not the way the regulation reads. And again, if you think about it philosophically, what the department's trying to get at is whether or not there's been some sort of payment or judgment that affects the institution's financial wherewithal, and whether or not that was a payment or judgment to a student or to a third party really is irrelevant. The question is whether or not it impacts the school's financial responsibility. So I do not believe that that is limited to, it's certainly not limited to BDR claims, and I also don't think it's limited to, whether the payment or settlement was with a student. Let's see, if your crediting agency asks for a teach-out plan and not at the institutional level, a program teach-out plan and not at the institutional level, is that still a reportable item? That is a great question. I do not know the answer to that. I certainly think there is an argument that would not be a trigger. I guess the question is whether or not if an accreditor asks for a program-level teach-out plan, if that's really a request that's been made pursuant to that operative regulation that the department is tying into the financial responsibility triggers. And my guess is it may not be. That is a great question, and one that I think would require a little additional exploration. If a former student files a complaint with the college, and the college, to avoid litigation, reaches a settlement with the student, is this a triggering event that requires notice to the department? Yes. And you have to supply the department with information regarding that settlement. And what's interesting is when bar defense was being negotiated, the second BDR2 and BDR3, someone pointed out, I mean, you're potentially incentivizing institutions in certain cases not to settle, right? Because theoretically, if you think you can win in litigation and you wouldn't end up with a final judgment that required a payment, I don't know if folks are really this concerned about the notice requirement, but let's just say hypothetically, you might forego a settlement which has to be reported in order to pursue litigation where you think you won't have a judgment and there will be no reporting requirement. I'm not sure, frankly, most of us would allow the notice requirement to dictate whether we settled or went on to litigation. But there was at least some conversation around whether or not this was creating a perverse incentive for folks to forego settlement. And the genesis of that was this question. For a family-owned school, should the reporting be done by a family or non-family member? I don't think that matters. The department doesn't offer any guidance on who should do the reporting. It's the school that has the obligation. So, whoever an appropriate official at the school might be. How do schools calculate the loan repayment rate referred to in the end? The department calculates that loan repayment rate, and my recollection is they are using the same formula that was introduced, I think, with the gainful employment rules. There were 2 or 3 different loan repayment rates that they had to choose from that were already out there, and instead of inventing a new one when they actually did the final rule, I think their feeling was, well, we're already generating repayment rates with data that we've got that we're getting from other sources, so we can just use that repayment rate and that data. So I don't believe there's going to be additional reporting requirement. I don't think that school actually has to calculate the rate. I believe it's something the department will do. Let's see here. Regarding misinformation, how do we handle a potential student exhibiting a disability that could result in that potential graduate's inability to obtain employment in a particular field without causing a concern of discrimination or misinformation? Should we include a statement on our enrollment application that could cover this or handle it in another way? So this is really an ADA compliance question. I'm going to give you a 30-second answer, and it's this. Every institution on this call should have what you call technical standards, and you supply that to prospective students. And by the way, I'm getting some interference on the line. I don't know if you don't have me on mute, please hit the mute button so we can try to keep that off for everybody else. You should have technical standards for every program, and those technical standards can relate to both sort of physical requirements that are needed to graduate and mental and professional requirements as well. and you provide that to a student and what it says to a prospective student, and it basically indicates whether you have a disability or not. You have to be able to satisfy these technical standards to remain in and graduate from the program. And if you are unable to, you may be dismissed from the program. Now, if someone does have a disability, then you have to get in a conversation around whether there is an accommodation that would allow them to satisfy those technical standards and whether or not you have an obligation to supply that accommodation. And that should be under your ADA disability accommodation policy, right? But you all need to have technical standards for every program because, and this is the critical reason, because if someone, for example, doesn't request any accommodation at the outset, or maybe they develop a disability during your program that no longer allows them to satisfy the technical standards, you want to be able to have something that you can clearly reference, right? And say, and if you go out right now and you Google nursing program technical standards, you will find that, you know, whether it be a for-profit or nonprofit or state institution, lots of nursing schools and programs and medical schools, they all have technical standards for their programs. And this is exactly why. Because it's part of that disability and accommodation conversation. It makes clear to students up front what's going to be required to get through and graduate from the program and when there might be an issue that requires action on the part of the institution. Sorry, that was a lot, but this is something I know a lot of schools don't have and you all need. If you don't have those technical standards, get with your attorney or whoever, your compliance folks, and talk with them about what that means. Google nursing program technical standards, and you can get some examples of what I'm talking about, and you'll see the value. Let's see. And that's how you avoid any allegation of misrepresentation, because you've been very upfront and you've documented the expectations for the program. Let's see here. All right. I don't know, Jeff or one of my producers, again, I'm losing the questions here. My screen is wonky. Could you go to the next question and read it?
Oh.
Let's see.
Oh, question here. How does this affect claims that might be made by clients in student clinics, student-run restaurants, etc.?
Claims that might be made by clients. Well, clients aren't DL, direct loan recipients, right? So remember, you can only seek a discharge of a direct loan if you're a direct loan recipient. So if you're a client, as far as like the bar defense framework and discharge, it shouldn't apply. And where you're talking about pre-dispute arbitration, class action waivers, you know, you don't have agreements with a customer. But if you're talking about what if someone, a third party, slip and fell, or a client in a restaurant or something like that had a claim, if you had a settlement or a final judgment come out of litigation, you would have to report that under the financial responsibility framework. So I tell you what, I think, and we're getting pretty tight on time, and I tell you what, we've got other questions. So let me suggest this. If you're on the webinar and you have other questions and you want to reach out to me on the side, I'm happy to try to get to your questions. If you are a client of ours, of course, you are very welcome to reach out and we can talk through all of this. If you're not a client but you'd like to be, certainly happy to chat with you as well. But as a general matter, appreciate everybody tuning in. Please pay attention to the guidance. Please get with your counsel and make sure they're aware of this if they're not already, and talk through with them whether or not you think you have a reporting or other obligation. Otherwise, I hope everyone is well. Appreciate you tuning in, and look forward to the next webinar. Bye all.